Welcome everyone, and thank you for joining the Berkeley team today for our year in review, financial lines, claims trends and examples. Just to introduce the panel to you today, we have myself, Trish Cuthbert. I am in our Vic office, State Manager. Nicole Carey is based in our Queensland office. She is the National Head of New Product Development and Senior Underwriter. We've got Angie Sunthornson, who's also in our Brisbane office as an underwriter, and Joe Thornton is in our WA office. Sorry about that, Joe Horton, our WA office, who does have a minor tickle in her throat today, so she may be a little bit coughy and apologises in advance, but I'm sure we'll all get through it. So before we start today's session, there's our usual housekeeping that we'll just reiterate to you. Today's session will be recorded and the link will be sent to you in the next couple of days. And it will also be uploaded onto the Berkeley website by the end of the week. During the session, we invite you for your comments and questions. Please select the Q&A section on your screen, and we'll also have some polling questions with using Slido during the session. So once the question pops up on the screen, you'll be able to add your answer. We'll give you a couple of minutes to complete those and share the responses with you. Importantly, if you have any issues with your sound, you'll probably find it's from your side. So please disconnect and reconnect, or use the call-in number provided in the audio options on your screen. If you can't see the presentation, please make sure you're using the WebEx app and not a browser, or you are outside of your company server. This can create issues and you can't log in. So please try those things if you're having any trouble connecting. In regards to CPD and CIP points, a certificate will also be emailed to you fairly promptly, and then you can claim the points online or on either the NEBA or the ANZIF websites. So again, thanks for joining us. Today we're talking about sort of the claims trends that we've seen in 2023, now that we've kicked off 2024 and we're almost in March, believe it or not. The session will cover ensuring that the correct cover is in place for your clients, and also just about the active management that you can take in managing claims for your clients. And then we'll finish off with what we observed during 2023 with respect to claims and trends. So on to the next slide. So is the right coverage in place? So we thought to kind of kick off this session, we would just talk about some fundamentals which you may already be aware of, but sometimes we find when a claim comes in, there's the understanding of what is covered and how the policy operates is perhaps not as clear as it should be. And we also sometimes discover that the policy maybe hasn't been reviewed in its entirety, particularly around the claims conditions, until a claim has arisen, and that's obviously sometimes a bit too late. So the policy structure, insuring clause, you'll all be aware of this. It exists in all different types of policies. Some policies have a number of insuring clauses in them, depending on the type of policy it is. But this is the gateway to the policy. This is kind of the first thing that you would look at to get an understanding, a global understanding of what the policy is covering and what the intention of the policy is. So the clause details the risks that the insurer is liable for paying and defines the scope of coverage. As I said, there may be multiple insuring clauses. So if you think about, say, a management liability policy, for example, there are 3 insuring clauses in that, and that's sort of your starting point for starting to review the extent of the coverage. And that leads us into the extensions. The name goes without saying, the heading goes without saying. Extensions are those additional things in addition to the insuring clause that we're covering under the policy. So some extensions are automatic, so the client can expect to get those as part of their purchase of the policy, and the others are optional. And optional usually means that they need to be elected, or it may also be at the option of the insurer as to whether that cover is provided or not. And that's probably why they're optional, because we want the opportunity to assess and understand the exposure and decide, how we extend the policy and on what terms and conditions, if there are any extra for those extensions. And then that leads us into the exclusions. I mean, I think, the headings are pretty self-explanatory. Exclusions go without saying what we aren't covering. Again, really important that the client understands what is not being covered under the policy, because this is where where there's limitations around what cover is not intended to be provided, and this section, as with all sections, should really be understood, particularly before there are any claims, to make sure that the insured doesn't have an expectation that something will be covered that there was no intention to cover that. So now we move into endorsements. So it can act as an extension, or it can also act as an exclusion. So an endorsement will usually be unique to a specific insured or even a specific profession, where it may be a clarification around something that is to be covered or clearly defined as not being covered. So we would encourage you to take specific note of any endorsements that are placed on any policy to make sure that you're fully aware of what is covered in the event of a claim. Definitions. So in the Berkeley policy wordings, you will find any word that is defined has a capital letter. So once you're reading the insuring clause and your extensions, normally you need to read, you jump around to the extensions, and then within each clause, you'll find a definition that relates to the operation of that clause. So then you need to jump into those definitions, understand what they are, and then within the definition, that may link into other definitions. So it's, sometimes it can be take a little bit of time to fully understand what the extent of the cover is. So the definitions that are capitalised and outlined in the wording are not definitions that are unique to that product. So we specifically want to make it clear that those words have a special meaning for the purpose of that policy. So make sure you read those and understand what they mean. If the word isn't capitalised and it's not related to a special definition, it will just be the commonly understood definition of that term. If in doubt, just ask your local underwriter. So claims conditions. This is probably the section that you might be surprised to learn that is not completely understood until there is a claim. And I suppose that's just, the great Australian way, that we don't expect that we're going to have a claim. And then when we do, we might discover there are things in the wording that we didn't understand. So there are several clauses that govern the way a claim will be handled. And I'd probably draw your attention to two, and one is the admission of liability and conduct of claims. So the admission of liability generally says that the client can't admit to liability, and the conduct of claims is how the claim will be managed, how we will conduct the claim. And what we have found is sometimes that an insured will enthusiastically go to manage a claim and appoint a lawyer on their own, on behalf, of the insured, and only to find that that's in contravention of what the policy outlines. So Berkeley has an experienced team of qualified claim professionals, and they also carefully select their panel lawyers to make sure that they're expert in the specific matter, so that we're getting the most efficient, and the best experts that we can to act on behalf of the insured to deal with the matter. So Berkeley's claims philosophy is to play fair and pay early, and that kind of goes to the crux of how they manage claims. So on to the next slide. Is the right coverage in place? So things to look out for. Again, these things probably go without saying, but the business description. So you'll see that in particular with a PI quote, for example, the business description will outline the activities that the insured is involved in. So if the we don't want this to be a laundry list of every activity that an insured is involved in. If the activity that they're involved in is typical or expected of their profession, you wouldn't need to list every single activity. However, if they were involved in an activity that was perhaps a little bit unusual for that profession, we would recommend that you speak to the underwriter firstly to make sure that the insurer's happy to cover that activity, and then also to have it noted on the policy to make sure that it's clear, in the event of a claim, that we intended for that activity to be covered. So just look at that closely, make sure that it reflects what the insured does, and as the broker, you are best placed to understand what the insured does, remembering that we're looking at what's declared on the proposal form. So if there's an activity that hasn't been declared and we wouldn't expect that to have been covered, it can just lead to some complications in the event of a claim. So just be really careful around that business description being accurate. Retroactive date is unique to claims made policies. So this is something else that you should, keep an eye on to make sure that it's reflective of what the insured requires, but also that more importantly, that they understand what it is and how it operates. So if it's a retro date of inception, then any acts that occurred prior to that retroactive date will not be covered in the event that a claim arises out of that. So just need to be aware, the client just needs to be aware of that limitation. The indemnity limit, this is always, this can be a tricky one in terms of how much should it be. This is the maximum amount that the insurer is going to pay under a claim. Under the policy with respect to a claim, and legal expenses may be included in the limit. So it's important to understand the operation of the indemnity limit being inclusive or exclusive of costs. So if it's an inclusive limit, then obviously the policy limit could be eroded by legal costs. So it's important to make sure that the client understands that and that the limit is adequate to cover not only the claim, but the amount of costs that may be related to that claim, and costs can be significant. So, the longer a claim takes to be settled, the more, the higher the quantum of legal costs. So, really important to understand that. Be aware of the excess as well. And again, that the excess operates on a excess inclusive or exclusive. So is the excess inclusive of costs? So what does that mean? The excess is going to apply to any cost. So that means from $1, the insured's going to be, sticking their hand in their pocket to contribute to the claim. So again, making sure that the client understands that they'll be contributing to that in the event that there is a claim. So the excess can be something that the insured decides to increase, and they may do that because they have a really solid risk management process and they're pretty comfortable with the way they operate, and they feel that the chance of a claim is unlikely, and in the event there is one, they're happy to contribute more. The benefit to them is that they will get some premium savings, or it may be dictated by the underwriter in terms of, what the activities are, and the size of the business will also dictate what the excess is. So from here, we'll go into our first Slido, and you'll have a little bit of time to answer this. So when an insured becomes aware of a claim or circumstance, what should they do? And we'll give you a couple of minutes to respond to that. And then from here, I will hand you over to Joe, WA.
All right, well, hi everybody, and as Trish mentioned before, I have a little bit of a tickle, so please forgive me if I jump off screen and exercise my demons. But we do have the Slido question up at the moment. Hopefully you can all see that. So The question is, when an insured becomes aware of a claim or a circumstance, what should they do? All right, so we have the two options available, contact and appoint their own lawyers or notify their insurer. So I'll give you a little bit longer to answer that one. All right, so hopefully we provided enough time for you there. So the answer to that question, hopefully pretty obvious to everybody, is notify their insurer, preferably before any costs are incurred as well. So I'm here to talk about the claims management notifications. So as mentioned earlier, managing claims for your clients is the single most important thing that a broker can do, besides ensuring that the cover that they have under the policy selected is appropriate to their needs. The Berkeley Claim Team award-winning service is predicated on the strength of our plain and simple claim philosophy, which is play fair and pay early. We appreciate that when a claim is made against an insured, the time waiting for a decision to be made on what assistance a policy may provide is uncertain and an angst-ridden period. So our goal is to alleviate this burden by processing your client's claim for insurance cover as quickly as possible, but your cooperation is crucial. So what to notify? So clients should be encouraged to notify anything that crosses their mind. So it's then up to the broker to counsel them on how and when to notify the matter to insurers, be it a circumstance or an actual claim. So we would encourage brokers not to make their own decision on whether a claim or circumstance is covered under a policy and leave that up to our claims team. Making a decision that a claim is not covered and failing to notify could actually result in a PI claim against your own PI policy. And there's usually no benefits to not notifying matters. What information to provide? So when notifying insurers, it's advisable to collate as much information as possible and provide a high-level summary of what the claim is about. This is usually done by filling in the claim form and providing any additional information available. So this could be an incident report, notes, correspondence, contracts or agreements, legal documents, medical reports, factual investigation reports, CCTV or surveillance footage, and that could be videos or photographs, letters of demand, statements of claim, as well as any other supporting documents that you're able to collect and provide to us. And if you're concerned that the information provided may require some protection, this can be done once our panel lawyers are appointed by insurance. So when to notify? Essentially as soon as possible, like I mentioned before, also prior to incurring any additional charges. And then we'll move on to the next slide. All right, so the process. What's the claims management process? Firstly, we assess the coverage. Our claims team will review the information and make a determination as to whether the claim or circumstance is covered under the policy. It should always be remembered that we should be on the same side. If a claim or circumstance is not accepted, it's because the policy does not provide the cover. However, the client may have an alternative policy in place that may provide the cover. So as an example, we often receive notifications under our management liability policies, which are not covered. However, they would actually be covered under a professional indemnity policy. And then we determine if any additional information is required to respond to the claimant's allegations. Once we have the necessary information, we will assess and determine what, if anything, more is required to respond to the claimant's allegations. This may include instructing a panel where there's a statement of claim or a court or tribunal process is in play. Alternatively, if it's a straightforward matter and the proof of loss, etc., has been provided, the matter may be settled subject always to a deed of release to protect both the insured and the insurer. All right, so we've got another Slido question for you. So I'll introduce this one. So from which industry did we receive the greatest number of notifications under our ML policy during 2023? So we've got a couple of options that will be available for you if you want to take a minute or so and select your answer, and I'll be handing over to Angie to continue on.
We'll give maybe another minute or so just to see what the result will be. we, enough time just to see what everyone answer is. So the our what do we notice during 2023 for under our email policy? So a lot of most of the questions actually come up as constructions and manufacturing. However, the correct answer is our top three email claim notification by industry is financial and professional services, followed by construction and manufacturing, and the employment placement services. Next slide, please, Nicole. So during the last 12 months, what we have received in our email book that we had, the majority of the claim that we received is the sections under the EPL, Australian Taxation Office, and also workplace health and safety and statutory liability. Now, what I'm going to be talking about in the next few slides will be about the employment practice liability. So claims under the employment practice liability can be involved unfair dismissal, harassment, or it's also about bullying as well, or unlawful terminations. Now, Fair Work Commissions also can review the claims around bullying. The other thing that you need to know is that Australian Human Rights Commissions can also hear about claim relating employment discriminations and unfair dismissal. Next slide. So the next two slides, it will be providing you with the EPL claim example. Now, it definitely going to appear to be an increase of the awareness for the claimants around their rights for their employment and discrimination. These also has a flow effects on the ML coverage. So I was going to give you some stats here. In the 2023, and the Fair Work Commission's actually receiving an application around 31,000 lodged in relation to unfair dismissal and general protections such as discrimination matters. The Australian Human Rights Commissions also received around 14,000 inquiries and about 2,500 complaints during the same period. So these figures actually are slightly higher than the previous period. However, it's slightly significant higher than the pre-COVID figures. So for the two claims that you have seen on the slides, it's basically one is failure to promote. So one that the employee is sued the insurer for 120,000, and then it's been agreed and settled for 65,000. Second claim is unfair dismissal during the serious misconduct, and its current reserve of 52,000. Next slide, please. So the next slide, we were talking about the safe and harassment-free environment. In this case, it's a claim for Australian human rights cases. So the general manager is actually using his positions to presenting an opportunity and exchange for the unwelcome sexual advance. So for this one, the Australian Human Rights Commission had agreed to award 26,000, and also in addition, 10,000 in defense costs also paid. So the employer felt liable for failing to take responsible steps to prevent harassment and failing to provide a safe and harassment-free environment. So next one, I'm going to be handing back to Joe, who will be talking about our ATO investigations.
Okay, thanks, Angie. So we have a couple of examples here, so we'll just read through those ones for you. So the first one, sorry, these are ATO investigation claims examples. The first one is an insured with numerous entities within their group of companies was subject to a GST integrated audit by the ATO. The audit covered 3 income years being 2019 to 2021, and accounting costs of approximately $49,000 was incurred by the insured. The second one, the insured was investigated by the ATO for an R&D tax offset refund that had been claimed. So during the investigation, the insured's accountant advised that there had been an incorrect treatment of costs and provided an amended return. The insured's cost in relation to the investigation were just over $50,000. And the last one, the ATO investigation and review of the insured's group tax affairs for the 2019 and 2020 years. So that one had accounting costs of $50,000 incurred by the insured. So this slide actually provides details of 3 different ATO investigation claims under our ML policy. You'll note that the costs incurred by the insured are not insignificant, being on average around $50,000. The ATO continues to focus their compliance efforts on individuals and entities that present a risk to Australia's tax system by intentionally doing the wrong thing, with numerous programs and task forces focused on ensuring individuals and entities are complying with their obligations. Sorry, excuse me. And I'm going to hand over to Trish here, and she'll help you with the workplace health and safety.
Thank you, Joe. So what we noticed in 2023 was an increase in late notifications under WH&S and statutory liability. So these claims relate to injury to employees, contractors and labour hire workers for serious workplace injuries. So this is quite a difficult area for us. Well, it's a difficult area because we believe that coverage provided under ML policies is a commonly misunderstood area, and we encourage you to encourage your clients in the event that they have a workplace incident, that if they have an ML policy, that they notify their insurer, whoever that may be, because there may be coverage that's available under that policy to assist with it, and it may be that a better outcome can be achieved if we're notified as soon as the issue occurs. It's not always front of mind with workplace incidents that the ML insurer should be advised. So this is a good this claim was a good practical example of regarding prudent and early notification. So a serious workplace injury had occurred on site, and the Berkeley wasn't notified of the WH&S investigation, and the insured went ahead and incurred the legal costs for the investigation. So, earlier on in the presentation, I touched on, conduct of claims and how, Berkeley needs to be notified. This is the way the policy operates. So, in order to achieve the best outcome for the insured and to make sure they're not incurring costs that will potentially not be covered or not be covered in totality, it's really important that we're notified. So in this case, the regulator issued a fine against the insured, and they decided to not to plead guilty and to continue to challenge the fine. And it took a number of years for it to finally be finalised. Once it was finalised, Berkeley were notified, and in that time, the legislation had changed in Victoria, and we actually weren't able to pay the claim. I mean, there are a number of issues here. Firstly, that it was a late notification. But had they have notified, we may have guided them in a different way as to how they responded to the regulator, and it may be that we could have settled the claim and assisted with it being finalised much faster.
Thanks, Trish. I'm just going to move on to what we noticed sort of in the past 12 months under our professional indemnity portfolio. And it's just important to remember that when we're talking about
the trends that we've noticed. It relates to the Berkeley insurance portfolio. So there's some industries that we don't play in, and they may have higher rates of notifications, but we don't have that information because we don't underwrite those risks. So based on the number of claims notified per profession, the highest number of notifications received under our PI portfolio during the last 12 months were for architects, real estate agents, and coming in equal third, IT consultants and accountants. This split is fairly similar to the split that we had the year before in 2022. However, during 2022, we received an unusually high number of notifications under our association's liability product. So just addressing some of those professions, a large proportion of our architects' claims arise from not the design or drafting undertaken by architects, but from their project management activities. On numerous occasions, disputes have arisen around discrepancies between the insured services that they're providing and the services that they detail in their contracts. So as a broker, it's important to ensure the business description, which Trish spoke about earlier on an insured's professional indemnity policy encompasses all the services the insured is providing. Just when we're speaking specifically about architects, we do understand that architects do undertake project management activities. So the key thing there would be to make sure that they identify those activities in the split, the addendum split on the proposal form. So the real estate agents' claims are quite interesting. Most of these claims relate to real estate agents who are acting as property managers. And the claimants are alleging the insured has breached their duty by failing to arrange repairs for unsafe properties. So in a similar fashion to personal injury claims, a significant number of these notifications are notified to us later in proceedings. Generally, the first point of call is the general liability policy. And just in the past couple of weeks, we've received some late notifications from the actual general liability insurers subrogating back against the PI insurers. So that might be something to consider when you're placing a PI for a real estate agent, that you actually place the GL with the same insurer, because it's going to stop that argy-bargy a little bit further down the track. And the last one we've got up there are accountants. There doesn't appear to be any particular trend with the accountants' claims. They just they're quite general in nature, claims arising from the provision of incorrect advice or the failure to provide the correct advice, which led to the claimant suffering a financial loss. I'm just going to cover the IT consultants on the next slide. There's a bit of a question there for you. It's in are IT liability policies becoming cyber liability policies? So we're starting to see a number of PI claims against IT consultants, which are arising from cyber attacks on customers of the insured. So the insured's customers have been the subject of a social engineering claim, and then they're subrogating, or they're bringing claims back against their IT consultant saying you haven't put the correct systems in place for us. In addition to the insured's customers potentially bringing claims against them, we have seen a number of cyber liability insurance subrogating back against the IT liability consultants and their professional indemnity insurance policies as a result of payments made under the cyber liability policies. So this is effectively turning IT liability policies into potentially cyber liability policies, which is not necessarily always the intention. So the scenario with the is a real scenario, and it's led to quite significant losses being claimed. So whilst we encourage our insureds and our own staff to make sure that they have sufficient training in social engineering and phishing, it's also important to get your IT consultant clients to make sure that they're encouraging their insureds to train their staff at the same time. So the next slide that I'm putting up here, just sort of going into what we think is going to be happening over the next 12 months. This slide compares the number of insolvency appointments as at the 14th of January each year from 2022 to 2024. As you can see, there is still an increasing trend of appointments due to the administration's receiverships and liquidations. Unfortunately, we don't envisage any slowing down of the effects of the current economic environment. In this slide, we've only highlighted the top 5 industries with the construction industry being the highest by a significant amount. The chart doesn't include the number of insolvency practitioner appointments across the manufacturing industry. However, we can confirm it follows a very similar pattern to that of the other identified industries. And the reason I'm talking about the D&C is so things that we think we need to be aware of, and potentially you when discussing these things with your clients over the next 12 months. So starting with the construction industry, as previously mentioned, the number of appointments of administrators, receivers and liquidators are continuing to rise. We receive notifications on a regular basis. We believe the rising number of administrations and insolvencies will affect most insurance policies, not just our financial lines policies. So when a company is placed into administration or receivership, the company and its directors and officers and their practices and procedures will always be questioned. This can lead to notifications under the ML policies. And other practices that can affect other policies as well as ML policies include cost-cutting measures initiated or implemented by the companies to try and get themselves out of those situations before they're placed into administration or liquidation or receivership. So a real example of that was with Porter Davis last year. One of the cost-cutting measures that they had put into place was they were signing on new building contracts. However, rather than putting the home warranty policies in place when they took on the contracts, they were waiting to put those policies in place until all the approvals for the parcel of land and everything had been authorised. So what that actually meant was that when they went into liquidation, that there was a huge number of their clients who would normally be able to rely on their home builder's warranty insurance policy that the builder's responsibility to put in place, weren't able to do that because there was never an insurance policy put in place at that time. So the next example I've got up there of things to watch is employment practices liability. This one's fairly new. Just recently, I think the last couple of weeks, there's new legislation that's been introduced under the Fair Work Act, which now prevents employers from contacting their staff outside of their general employment hours. So we think it'll be interesting to follow this and to see if these new laws and employees' understanding of them will lead to an increase in EPL notification. So just throwing some things out there, if one employee is happy to respond to their boss after hours whilst another one isn't, will that employee get preferential treatment? Should that employee get preferential treatment? Would that result in a claim against an insured? Will the new legislation lead to an increase in bullying and harassment claims or allegations? So that'll be an interesting one to watch to see how it all works. And the last thing we've got on there is increasing costs, which is sometimes referred to as social inflation. Whilst we have agreed rates with our panel insurers and can limit costs in this respect, we are unfortunately unable to limit or control claimants' costs. This applies to legal fees and other associated costs, which along with most other costs in the current economic environment are on the rise. So this is why it's very important to notify and engage with our claims team as soon as possible to try and avoid lengthy claims processes where possible. Engaging early, play fair, pay early, which is our claims motto. This helps to keep the legal costs down from the insured's point of view and hopefully also limit the cost incurred by the third-party claimants, which will ultimately have a positive effect on the insured's loss ratios and claims reports. So, next slide. So we're almost coming to the end of our presentation now. So there's sort of 3 key takeaways that we've got in relation to insurance policies and claims. The first one is ensure that coverage is appropriate to your client's needs. Make sure you consider the policy wording, the business descriptions, the indemnity limits and deductibles, everything that Trish has spoken to before, and make sure you also have a good understanding of those claims conditions within a policy, and more importantly that you're insured, your clients has a very good understanding of what they need to do sorry, in the event of a claim. The second point we've got there is to take an active role in managing claims for your insureds and engage early with their insurers. Most insureds, when faced with a claim for the first time, can become overwhelmed and anxious. The appointment of specialist panel lawyers to help guide your insureds through the process. And our panel insurers will help assist your clients and guide them through processes, even whilst we're still determining our indemnity stance. We're not just going to leave people necessarily high and dry if they need our assistance in those situations. But the feedback that we've received is that that sort of service is always really appreciated by insureds and their brokers, because it's quite a stressful time. And the final one we've got on there is just to encourage your insureds to notify. Notifying us of a circumstance which doesn't develop into a claim won't be detrimental to your insureds, whereas if you do fail to notify a matter in good time, it could result in limited coverage, or in worst case scenarios, no coverage being available under the policy. Any questions?
There is a question.
Oh, yeah. So Andy's got a question that she can read for us.
So the question is, what happened if our insured got notified years after the incident occurred?
Okay, so just to clarify, the question was, what happens if the insured first becomes notified?
Got notified years after the incident occurred.
Okay, so that's a very complicated question, because a lot of it will come down to what the insured's knowledge was when the incident happened. If the incident happened and the insured was aware of it, and a reasonable person think, oh, that maybe could end up in a claim, then that might be considered a late circumstance. But if an incident happened and the insured only got notified of it or first became aware of it 4 or 5 years down the track, then that policy that's in place 4 or 5 years down the track is the one that should probably respond in that situation, and it wouldn't be detrimental to the insured. Trish, did you have anything to add to that one?
No, I think that, it's, if they genuinely weren't aware of it, then the policy that's in, the active policy when they became aware should be the one that responds. That's perfect world, right?
Yeah. Yes. Any other? We do have a little bit of time at the end, so if anyone has any questions, if you want to pop those into the chat, we can stay online for a little bit longer. Got a bit of time up our sleeves. Trish or Joe, did you have anything you wanted to add?
Sorry, I've been trying to stay on mute because I've got a bit of action in the background here. I don't have anything to add, but welcome any questions that come in, of course.
Yeah, no, I suppose I'll just reiterate what Nicole's already said about the, notifying, and that it's not detrimental. So, please make sure that insureds understand that if they notify us of a matter, that they won't be penalised just for notifying. So it's better to err on the side of caution, even if it's, they think it's, that it's not going to, that the matter's not going to go anywhere. There's no harm in letting us know that, we can't overemphasize that. I think we're probably done if there's no more questions.
So I think there's no more questions coming through. So thank you very much for your time. Keep your eye out for your invitation for next month's webinar. And if you do think of any questions, just before we go, there's one last question. Do you have any issues if claimants want to use their own legal counsel instead of panel lawyers? Yes, and I don't know if issues is the correct word to use there, but we think it's beneficial for our clients to use our panel lawyers. We employ a broad range of lawyers who are experts in the different areas of law where claims are coming into us. They also, our panel lawyers' rates are a lot more competitive compared to what their insured's own legal counsel generally are. I mean, we've had examples of claims where we've been notified late and the insured has used their own sort of local solicitor that they normally use, and the costs incurred and the time it took to finalise that claim was significantly higher than what we would have what would have eventuated if we had have given the management of that claim over to our panel lawyers. So, Trish, I won't ask her because she's having a coughing fit.
Yeah, I would. Yeah, just mirror exactly what Nicole said. Then our, if our panel are dealing with these matters all of the time, so the rationale is that they can deal with these matters more efficiently and get the best outcome from the insured. So we're not inclined to allow the insured's own legal representation to take over and conduct the claim.
There is just one question here that I did want to respond to, and the question was, do you still offer cover for IT consultants? The response to that is yes, we still do offer cover for IT consultants. However, we have had a little bit of a change to our underwriting guidelines in relation to managed service providers. So if you reach out to your local underwriters, they can have a more specific, in-depth conversation with you around that. But yeah, we still definitely provide IT liability insurance for IT consultants. So I think we might... So once again, thank you for your time today. Keep your eye out for your invitation for next month's webinar. And if you have any queries, feel free to contact your local underwriters because they know all of this that we've spoken about today. So thank you, everybody.
Thanks, everyone.
Thank you.